Okay. So again, good morning, everyone. This is Washington Arbitration Week. My name is Jose Antonio Rivas. I'm together with Ian Laird from Carlson Mooring, one of the co-founders of Washington Arbitration Week. This is our 5th day and last day. And it has been a marvelous experience. We've had greater numbers than any year, fully in person. And before starting, I would like to give my great appreciation to Wiley here, a DC-based firm. Thank you, Josh, for your hospitality. Without you and without other sponsors and hosts, it would not be possible to do a Washington Arbitration Week. We would also like to thank our advisory committee, and to my left is one of the members of our advisory committee without Marine's help and also counsel on some of the topics that we choose for for Washington Arbitration Week. It would be, frankly, impossible to do it. I would also would like to give a shout to our team back in Strategy in Bogota, Juan Pablo Rodriguez, and here in DC with me, but also in Bogota, Maria Lucia Casas, and the team also from Cornwall that has been helping us, and especially Ian. Today's topic is, and by the way, I'm from Strategy LLP, which is an investor state arbitration law firm here in DC. Today's topic is one that we have been following for now, I believe that more than 5 years. It's the UNCITRAL Group 3. We called it somehow differently this time, but because we wanted to see if that picks up, to see if there are any regional geopolitics behind it. There always are. I might be a little bit altruistic as to uncover what is the geopolitics behind it. I don't know whether we'll succeed, but at the very least, what we want to hear, we would love to hear, is the status and some of the ongoing discussions and perhaps the sticking points as of now. But that is not my place to develop anymore. I don't want to steal Marine's thunder. My job here is to introduce Marine Carlson. Recently left Sidley Austin, and she became an independent arbitrator. She's building on 25 years of experience in investor state and international commercial arbitration. Prior to launching her arbitrator practice, she was a co-leader, as I said, of Sidley Austin LLP's global arbitration, trade, and advocacy practices, where she was a partner specializing in investment treaty arbitration and represented claimant, investors, and respondent states in roughly equal measure. An academic analysis of the investment treaty arbitration community placed Marine in the top 25 most experienced ISDS counsel in the world. Not a small thing. Among the core lawyers who dominate the caseload. She is named as one of the top 250 women in litigation by Benchmark, and as one of Latin America's top 100 female lawyers by Latinvex. Marine is also an adjunct professor at George Washington University Law School and the American University's Washington College of Law, teaching investment treaty arbitration, a member of the executive committee of the Foundation for International Arbitration Advocacy, recent vice president of the American Society of International Law, and just completed 8 years of service on the board of directors of the CARE Coalition, a Washington, D.C. legal service organization focused on immigrants' rights. And I must emphasize that she is one of the members of the advisory board of Washington Arbitration Week. That's the most important thing. So, Marine, thank you and welcome.
Thank you so much, Jose Antonio, for the very comprehensive introduction. But you definitely also hit the high point at the end there. So we are assembled this morning to talk about, according to the title of the panel, the geopolitics of UNCITRAL Working Group 3, and discussing representative positions on different issues. I should have warned Jose Antonio, however, that the panel is probably going to go rogue. And that's because in talking about this topic, we thought, the notion of geopolitics sort of conjures up visions of realpolitik, which I guess is appropriate this week when we're thinking of Henry Kissinger's passing. The idea of political blocks, north, south, east, west, in Cold War terms, Western democracies versus communist states, developed versus developing states. And the suggestion is that there's some sort of predictable pattern there as to who allies with who and takes what positions on what issues. And as we were discussing that in the context of Working Group 3, it seemed to us that that actually isn't really the case. In a lot of the issues that are before Working Group 3, you don't see those sort of realpolitik patterns of alliances. And some of the patterns in which states take positions on different issues changes from issue to issue as well. So we decided to abandon the title of the panel, at least, not the topic. But the panel's going to brief us on what's happening, on what the main themes and common threads are of discussion on some of the hot topics at Working Group 3, but maybe not from the lens of geopolitics as such. So to introduce our panelists who are going to help us with that discussion, I will start with the traditional, what should be assumed at every panel, but the traditional caveat that, of course, none of our panelists are speaking in an official capacity or presenting the views of their respective governments, employers, et cetera. But they come to us with a wealth of experience. So we're joined online from Vienna by Jae-Sung Lee, who's the Senior Legal Officer in the International Trade Law Division of the UN Office of Legal Affairs, otherwise known as the Secretariat for UNCITRAL. And he has been with the United Nations since 2007, previously having served in the Korean Ministry of Foreign Affairs. His other projects at UNCITRAL have included the Singapore Convention on Mediation and service as Secretary to Working Group 6 on security interests. But of course, he's here today because he's serving as the Working Group 3 Secretary and therefore so deeply involved in the entire project from UNCITRAL's institutional perspective. We're also joined by Margie List-Jaime, who wears a number of hats, one of which is professor at the University of Panama. But for this purpose, she's a legal advisor at Panama's Ministry of Economy and Finance, advising on treaty-based investment arbitrations. And of course, serving as Panama's representative to Working Group 3. And she was also a former trade negotiator for the Panamanian government as well. Then the next down the table is Josh Simmons, who's a partner here at our host, Wiley Ryan, in the Global Disputes Practice, also an adjunct professor at University of Virginia Law School, and came to Wiley having, with previous service, in posts as senior advisor and earlier attorney advisor at the Department of State, advising the United States in international disputes and treaty negotiations, international investment disputes in particular. And then at the end of the table, we have Karen Kaiser, who's attorney advisor in the Office of Private International Law in the Office of Legal Advisor at the State Department. She joined the State Department in 2006. She represents the United States at UNCITRAL, including Working Group 3, as well as at the Hague Conference on Private International Law and UNIDROIT. Previously, in other roles at the State Department, was involved in BIT negotiations and implementation, and in the litigation of ISDS cases at the Office of Claims and Investment Disputes. So as you see, we've got a very actively involved panel who knows well all of these issues and can bring us up to speed on them. Our order of proceedings is going to start with asking Jay to give us sort of an overview of how we've gotten here in the approximately 5+ years that Working Group 3 has been underway in its project to look at ISDS reform and to talk about what's been accomplished so far. And then we're going to turn to some of the specific topics that are currently on the Working Group 3 agenda. Margie List is going to talk about the appellate mechanism discussions. Josh is going to take up the advisory center, and then Karen's going to launch us into the current hot topics of procedural reform and quote unquote cross-cutting issues. And for each of those, they'll tell us what's on the table, what are some of the key stakeholder views, and what's the process going forward, what's next. So with that as our introduction, I will turn it over to Jay to tell us how we got here.
Thank you, Maureen. Hi, so this is Jay. I was just introduced. So I'll tell you about where we are and how we got here. I think that's what I wanted to focus on. So just going to where we are. In July of this year, in the summer, the UNCITRAL, as we know it, finalized the first set of reform elements in ISDS reform. So this included 2 texts on mediation, investment mediation, a guideline on mediation, and a model provisions for states to adopt from, and 2 codes of conduct. One was adopted and the other was adopted in principle. The code of conduct for arbitrators was adopted, and the code of conduct for judges was adopted as in principle, because we have not finished the work on the court. But as you mentioned, rewind back 6 years, it was at that time in 2017 that the Commission entrusted Working Group G with a very broad mandate to conduct ISDS reforms, to identify the concerns, considering the result, the desirability of the reform, and to develop relevant solutions. And that's what we're doing now. We're at the 3rd stage where we're actually developing solutions. But you have to rewind back a little bit longer. And actually, I'm going to bring you back 15 years, because I think UNCITRAL started to work on the ISDS reform when it started to look into transparency as it was revising the UNCITRAL arbitration rules. The issue of transparency came into issue, and they said that the Commission said that there should be rules that are developed to ensure transparency in ISDS proceedings, which resulted in the transparency rules and the Mauritius conventions that followed. So after that, this was where kind of ISDS came into the picture of UNCITRAL, and in 2017, we got a mandate starting in November 2017 with the first working group. And since then, we've had 14 sessions, 10 sessions in Vienna and 4 sessions in New York. So that's where we are. So this is an intergovernmental process. I know that there has been some mentions about experts preparing this, but it's actually the governments coming together to actually negotiate these reform elements. It has been based on consensus and transparent manner. We've also had a number of efforts to coordinate with different international organizations. For example, the codes of conduct were drafted very closely with the ICSID Secretariat, and we are cooperating with UNCTAD, OECD, the WTO, and on a number of different matters. Now, while broadly it's in line with the UNCITRAL practice of negotiating different texts, but I think it has been unprecedented in a number of manners. The number of delegations that are participating, cooperations with the multiple IGOs, the increased use of informal means, especially due to the COVID pandemic, hybrid meetings. We also have the intersessional meetings, which is beginning to be a lot of something that people want to host. And we have a silence procedures to adopt our reports, and additional resources by the General Assembly to hold 1 more session of the working groups during the year. So I just wanted to give you a very brief overview of where we are. So after the Commission, what happened was that there was an intersessional meeting in Singapore hosted by the government of Singapore, where we discussed the elements of a standing mechanism and an appellate mechanism. So we looked into kind of the rationale and implications for the standing mechanism, what are the possible models, scope, governance, how it can exist within the existing mechanisms, or whether it has to be separate. And this was kind of thought in more in depth. And the idea is that this reform element would be presented to the working group in April of next year. I guess, yeah, it's next year, yes. So that's the plan. And then in the October of formal session, which is the 46th session, the working group considered 2 other topics. 2 main topics. One was the advisory center in the international investment law, whereby the working group agreed that the center should be established as an independent intergovernmental body composed of states and REIOs, that it would work to prepare a draft statute of the advisory center, which would form a protocol to the multilateral instrument that the working group is working on. And while there was support for providing legal assistance on proceedings, representation services, there were some questions about that. Also, discussions also evolved about whether the advisory center should provide services on state-to-state dispute settlement and so on. Most of the discussions focused on the services to be provided by the center, who the beneficiaries would be, and what the priority should be, because it's probably with the limited resources that the advisory center would have, it wasn't clear that all of the member states would be able to access the center. And of course, as I mentioned, representation services was also hugely divided, with some priority to be given to LDCs and developing countries if their request is to be made. Now, as to the financing, which is an issue that we're looking into on how to finance the advisory center, it was generally agreed that the contributions from the member states and fees to be charged to the states would be the main sources of the financing, but open to other voluntary contributions that may come into the picture. Now, another topic that was discussed is what Karen will touch upon, which is the draft provisions on procedural and cost-cutting issues. I know that if you look at the paper, it's a quite long document with a number of draft provisions, but this is what the working group has been kind of piling up for the Secretariat to prepare, and we try to compile them into a set of provisions for considerations by the working group, taking a look at some of the conditions that have been mentioned for raising a claim, some of the conduct of the proceedings that would undertake place, provisions that would relate to the efficiency of the proceedings, and finally, provisions on the awards or the decisions to be made by the mechanism. One thing that I wanted to mention there, just in case, is that we have not delved into what the procedural rules for the standing mechanism would be. And we also kind of thought that these procedural reforms, whatever the working group is about to agree on, should also apply to the standing mechanism. And that was the basis of our discussions. So where we go from now, the working group is expected to present the results of the work on advisory center and the guidance document on dispute prevention and mitigation to the Commission next July. It is planned that the working group 3 issues would be discussed in the earlier weeks of July, and we'll have to see, because I think the current work on ISDS reform entails a lot of complexities, especially because states are to be given flexibility in undertaking those reforms, and that adds a little bit of flavor of what kind of provisions we can prepare and present to the working group. And it's a daunting task. We have 2 working group sessions that we will have till the Commission. We are meeting in January in Vienna and April in New York. And in between, there will be an intersessional meeting in Belgium, Brussels, to look at the access to justice issues of a number of the reform elements. So that's where we are. Thank you.
Thanks so much, Jay, and for previewing some of the things that some of our other panelists are going to go into a little more depth about. So Margie List, I'll turn to you to pick up one of those issues, which is the appellate mechanism, permanent investment court, whatever we're calling it these days.
Well, they're different.
Exactly. And that's part of the discussion, as I understand it. So please fill us in.
Thank you so much, Marin, and thank you to the organizers, Jose Antonio, and it's a real pleasure to be here in Washington to discuss about these issues. So the appellate mechanism is not something that is new, right? We have been talking about that for the past 20 years. So it has been included in some of our treaties, and actually the one between Panama and the US have the possibility of implementing an appellate mechanism. And more recently, Panama also negotiated a treaty with a free trade agreement with Korea, which include also that possibility. So it's not new, and the ICSID Secretariat, as we know, in 2004 published a discussion paper also discussing about this possibility of implementing an appeal facility within ICSID. At that time, it was said that it was too premature, but now 20 years later, we're still discussing about these issues. It wasn't included in the recent reform of the ICSID rules, but we know that probably one of the reasons is because it's under discussions at the working groups 3 at UNCITRAL. So why talking about an appeal mechanism? Or why there are so many countries that are interested in perhaps implementing this this option. As we know, this is one of the two systemic reform options. The other one was already mentioned by Margie, that is the multilateral investment court through a standing body, well, and also, of course, by Jay. So what we need to differentiate, so with the current system, that it was actually made basically for contractual relationships at that time in 1965, when ICSID was established. Of course, there were not that many treaties, but now we know that over 60% of the cases are based on bilateral investment treaties. Most of them are from an old generation of treaties before 2010. So the idea of having an appeal review is to being able to have that correctness of the substance. So to modify or to reverse the legal findings of the first instance tribunal. So that is the key feature. And then, of course, the annulment proceeding is always, it's only focusing on the legitimacy of the process. So it could only void the award. And then if you want to continue, then you have to start all over again with a new tribunal. So I would like to focus in 4 different aspects that are under discussions. It's not everything that is on the paper, the last paper that we will be discussing in April 2024. But it's at least, it could give you a flavor of what we are discussing at working group 3. So the first one is the scope. So what type of decisions are we going to put it subject? It would be subject to an appeal. So not all type, for example, no procedural orders, nothing that is related to a challenge of an arbitrator, but more substantive. So there's a whole discussion on whether only final decisions should be subject to an appeal, as is currently at ICSID with the annulment proceeding. So if we go, and I have to say this, everything that I'm going to comment right now is under discussion. So it's not like, and there's nothing, final, right? Because it is still under discussions of under these states that are participating. So jurisdictional decisions. So what happened if a jurisdictional decision that is decided to hold the proceedings goes to an appeal? So in that case, there's a risk of parallel proceeding, of course. So then we're discussing whether there should be an automatic suspension or not of the proceedings. So that's, I think, one of the interesting things. Also, whether or not interim measures should be subject to an appeal. So this is part of the scopes that we are discussing. Then a second point, we have the grounds of appeal, of course. And there's 2 elements that are different for an annulment. One is the manifest errors in the interpretation and application of the law. And the second one is a manifest errors in the appreciation of the facts, which could include an appreciation of the domestic law and also of course, the damages, errors in the assessment of damages. So that, I think that is part of the main discussions, because it will make a difference with the annulment proceeding that we have now. And the idea is not having cases like CMS versus Argentina, where an annulment tribunal tell you, there have been so manifest errors, but we cannot annul for excess of power because we cannot substitute the decision to our own finding. So with our own findings. So this, I think it will be key part of the discussions. Also, there will be other grounds included, taken from the ICSID Article 52, and some also from the Article 5 of the New York Convention. But here also is the discussion of whether some of these grounds that are in the New York Convention are not fit to an ISDS case. The third element that I want to briefly discuss with you is so the type of decisions that will be subject to the appellate tribunal. So the idea is the tribunal could uphold, modify, or reverse decisions in most of the cases, but also we know that there might be cases where there's a need to remand the case to the first tribunal. So there will be instances where it could be difficult because the tribunal is no longer available, or there's for example, in a case of conflict of interest or corruption, it will be hard then or impossible to get it into that tribunal. There's also a discussion on what it needs to be included in that decision. For example, the reason by the appellate tribunal. So in that case, it will need to specify how the decision will be modified or reversed and why. And of course, there's a need to also guarantee the finality of the decision, because the idea of having an appeal mechanism is not that then it will go again to an appeal or to an annulment. So it should be final. And for my last point, I would like just to briefly address the issue of the enforcement and recognition and enforcement of the award. So the whole idea is that as it is in the exit system now, so that decision could be enforced as a local court decision in any of the state members. But what happened with the third states? So the states that are not part of the instrument that approve the appeal mechanism. So there's an issue there as well that need to be discussed. And of course, in that case, there might be a residual role of the New York Convention for those states that are not part of the instrument that creates the appeal mechanism. So I think I will, with this overview, I will stop here and we can discuss a little bit more. And if you have questions on particular issues regarding the appeal mechanism. Mm-hmm.
Great. Thanks very much, Margie List. Josh, you want to bring us up to speed on the Advisory Center?
Absolutely. Thanks, Marin. And first of all, welcome. We're glad to have you all at Wiley this morning, and for everyone dialing in as well. I think Jay gave a good preview of the Advisory Center, but I just want to unpack a few more details. First, what is it? Kind of where did it come from? And then 3 of the open questions that are being debated right now. So what is the Advisory Center that's being discussed by the working group? The full name is the Advisory Center on International Investment Law. The abbreviation is ACIIL, and the current acronym. And it's not an unprecedented idea. And I think that's an important thing that there is a precedent to follow from the WTO. So there's an advisory center on WTO law that was established in 2001. And that center, I think many commentators agree, has been fairly successful. And what's the goal of the center? The goal is to increase the technical capacity of countries that are involved in these disputes, in a sense, a right of representation, so that they have adequate counsel, because many of the least developed countries might not have the in-house government experience, for example, to present their case well in a WTO dispute. And in the context of some of the criticisms that have arisen in investor-state arbitration, a similar idea has come to the fore with respect to this advisory center. So UNCITRAL has been discussing it for a number of years, and it's come together much more clearly in recent months. In fact, you can find it online, hot off the presses, November 27th, 2023. There's a draft statute of an advisory center. So this follows on discussions this past October, and will be continued to be discussed in January next year. And I understand that a goal is to have this draft statute largely completed by next July. So in a way, you can see now this advisory center, which is conceptual, following a precedent, now taking some shape. And There's bracketed text, of course, in the draft statute on some of the questions that are open. So I want to flag just 3 of those, although there are a number that will require some more detailed discussion in the coming months. The first is, what is the scope of the advisory center? So as the name suggests, it relates to international investment law. But international investment law disputes can take different forms. There are different players involved. There's the investor, there's the state. And as many of you know, most investment treaties also have a mechanism for state-to-state disputes. That could be, for example, diplomatic protection, espousal of claims, but it could also be submissions on interpretation of the relevant treaty. And so a big question that the participants in the working group have been debating is, can the center advise on state-to-state disputes? Can the center advise investors? Or is the center going to be limited to states that are defending against claims or potential claims by investors? My sense, and I welcome the input of those who have been in the room, but my sense is that there seems to be some emerging consensus around focusing on representation and advising of states that are defending against claims by investors. And you can see this in the terms of this draft statute. So what's the objective of the advisory center? Article 2 of the draft says it aims to provide training, support, and assistance with regard to international investment law or some form thereof. It wants to enhance the capacity of states and regional economic integration organizations in handling international investment disputes. So that's the scope. It's still being debated, but it does seem that at least at a minimum, the center's primary objective would be to facilitate representation of states in investor-state arbitration defending against investor claims. The second question is, what will that representation look like? The center is going to, it's contemplated that it will have a staff. This will be a working organization that has potentially, qualified lawyers who can provide this advice. And Articles 6 and 7 of the draft statute flesh this out. So one form of advice might be before a dispute arises. So for example, if a developing country is considering passing a certain law or a measure, that they might go to the center and say, these are our obligations under this investment treaty. Could you advise us as to whether there might be a claim or what that claim might look like? And I think that could be a useful facilitation by the advisory center, because it will be gathering best practices of states around the world and facilitating that exchange of information. The second, and I think this is the one that's going to be more challenging to implement, and where I think Jay hinted at the resource question, is the actual representation of the state in the arbitration. So Article 7, as it's currently drafted, includes that the advisory center may represent the member, that is the state who is a member of the advisory center, represent the member in the proceeding, including in a hearing, possibly in conjunction with a team of that member. So that's a question of resources. As anyone who's been involved in investment arbitration knows, these can be large, complex disputes that require substantial resources, both to bring the claim and to defend against the claim. And many governments from the developing world do not have robust in-house capacity to do this. So there could be, there seems to be a suggestion that there would be a team building, capacity enhancing function of the advisory center. So you can imagine a team of experts at defending states in investor-state arbitration at the advisory center, working together with the lawyers of the government involved in the dispute to advocate. But how many team members will there be at the advisory center? How much will they be paid? How many cases can they handle? I'm sure anyone who's been following Washington Arbitration Week or this field knows that the number of investor-state arbitration cases are rising, and a team, for example, of 15 at an advisory center could not possibly represent all developing countries in investor state arbitration. There would need to be more or some sort of compromise. And how do you rank which states who are members of the advisory center get preference in terms of representation? So these are some of the rubber meets the road, tough questions being negotiated now. The last question, and I understand this has not been intensely discussed yet at the working group, but I think it's a relatively fun one to think about, is where will the advisory center be located? And, you know, I'm going to give my informal pitch with no authority while we're here at Washington Arbitration Week. The Washington, D.C. is a great spot. But I'm sure that will be hotly debated in the coming session. So that is the advisory center, and I look forward to discussing it further with any questions.
Thanks very much, Josh. So Karen, we'll leave it to you to kick off the interesting discussion of the kitchen sink, which is how I've been thinking about the procedural and cross-cutting issues that have been under discussion, including at the most recent session. So where is this all coming from, and where's it going to go?
Thank you, Maren. Well, one thing I want to do is unpack a little bit so you can understand why we have a kitchen sink, or as I think Jay referred to them, a pile of issues for the Secretariat. I think we can perhaps put that a bit more delicately. But before I go into my remarks, I want to echo the comments of Margie and Josh and thank the organizers of Washington Arbitration Week for inviting me. And I've had an opportunity to speak before, and I've attended in the past, and the programs are just excellent. So I feel very honored to be able to participate. And then I'm also going to underscore that I'm speaking in my personal capacity. So what I say here doesn't represent my office, the State Department, the legal advisor's office, or the U.S. government. That said, I'm not planning to say anything super exciting, but just so that if something does pique your curiosity, it's my personal view. So I'll go to the procedural and cross-cutting issues because, of course, that is a bit of a clunky title, but we don't really have a better way to refer to them. And I think I'd like to kind of go back to how we got to these issues. Early in the working group's process, delegations were encouraged to submit papers on what types of reforms should be put before the working group and how it should organize itself. And one of the early papers was actually one that was put forward by Thailand. And Thailand proposed a so-called building blocks approach, where they wanted to make discrete changes that countries could then sort of put together. I like to think of it as the Lego approach, you know, where you can mix and match what you may want to do in terms of reform, assuming that you could have some kind of matching. And one of the things that was included in that proposal was updating the UNCITRAL arbitration rules to include proposals on procedural innovations, such as early dismissal of claims, security for costs, and regulating third-party funding. Later in the process, 5 countries, Chile, Israel, Japan, Mexico, and Peru, submitted a similar paper that kind of built on that concept, but they referred to their approach as the suite approach. And what the goal of that paper was to illustrate that there were actually a lot of common approaches in existing agreements, such as, Mexico was the example because Mexico had an agreement with the European Union, they had agreements with the United States and Canada, and they were also part of the Comprehensive and Progressive Trans-Pacific Partnership, or CPTPP. And what you could see is that many of the procedural issues in those 3 agreements were actually fairly similar. So one proposal there was to not so much amend existing agreements that already have those types of provisions, but to take those and retrofit earlier first generation bilateral investment treaties and agreements to bring them up to code, so to speak. Because of course, those are the agreements where we've seen many of the disputes, and they were the source of many of the concerns that had prompted UNCITRAL to take this work up. Now, that stream of procedural work was supplemented by proposals initially put forward by the then South African delegate to Working Group 3, but then supported by others that went into what are now considered the cross-cutting issues. And these issues picked up on topics like damages, which were of concern in terms of the way in which awards were perceived to be being issued on damages, concerns about ensuring that the right to regulate was clarified, and other questions about access to ISDS, in particular, the role of local remedies. So these strands came together last September 2022 and the working group's 43rd session. And that's when the Secretariat had been originally tasked with updating some of the initial procedural rules that it had been looking at. And then, as Jay said, the list began to accumulate. Every countries began to say, well, if you're going to update this, let's add that. And that process is what led us to the paper that we were looking at this past fall. Now, the other thing that had happened in the interim was that ICSID had completed its rules amendment process. And so where there had been a concern perhaps 4 years ago about treaties not or rules not sufficiently being structured so that they addressed procedural concerns. We now have the ICSID rules, which have adopted many of the types of procedural reforms that are being considered at UNCITRAL, in particular, clarifying the early dismissal of claims, addressing security for costs, regulating third-party funding, and what have you. So that's how we got there. Now, in the way that the paper was presented, there were sort of 3 categories, and Jay mentioned these, but I think the 3 categories are not equal in terms of, I think, the controversy and attention that they may get. So the first category was, as Jay mentioned, conditions on claims, and that category included some of what we might think of as traditional gateways to claims, such as a statute of limitations, potentially some kind of a waiver requirement, but also some other ones that we don't typically see in that space, which would be denial of benefits, exhaustion of local remedies, and provisions on the right to regulate. The working group has not discussed most of those. There was some brief discussion of some of the relationship of waiver and other conditions, but that's been postponed, and that will pick back up in January. The second category wasn't discussed at all, and that's primarily the procedural issues. And that's where we see the type of overlap with the reforms that have been achieved at ICSID, as well as other common, some of the common proposals that were flagged in the paper that was done by Chile, Israel, Japan, Mexico, and Peru. And in that context, those are probably the furthest along because the working group had already been looking at questions of early dismissal, security for costs, third-party funding, but there's still a lot to be done in that space. And one question there is, how much of those provisions need to be treaty language, and how much of them might actually be more appropriately an addendum or special chapter of the UNCITRAL rules that would apply to investor state dispute cases similar to the transparency rules. And so that is something that the working group is also going to be taking a look at. Now, the one topic that we did spend quite a bit of time on, and the paper developed quite or created quite a lively debate, was the topic of damages. And I think that topic is a good illustration of some of the tensions that are going on with these topics, because one issue there is the scope of the working group's mandate. There are some delegations who see the working group's mandate as very clearly focused on procedural aspects of ISDS. So one of the shorthand ways that you can think about it is, if you're familiar with, say, U.S. agreements, there's a Section A and a Section B. Section B topics are the type of thing that Working Group 3 could do. Maybe some categories, maybe not, but generally Section A outside the mandate. There are others, though, who interpret the language and see that the working group has been given a broad mandate and that it's not necessarily limited to procedural issues. And the way that the chair of the working group has sort of tried to square that circle is to say, we can have procedural approaches to resolve some of these substantive concerns. What that actually means, we'll have to see, but that's our mantra for how we go forward. And I just want to flag very briefly on the damages issue that was one where there was a fairly clear divide in the working group, that there were delegations that did not believe that it was an appropriate topic to consider, and others who thought it was essential to consider. And I know we've talked about the geopolitical aspect and how we're not going to talk about it, but I think damages is actually an interesting topic because I think there was an apparent divide, I would say, in terms of developing and developed countries, but it was also very mixed in terms of what countries' experience was with ISDS. And I think that's probably the more distinguishing factor. And I think that's a key factor in UNCITRAL is, although there are sort of regional groupings, it's really the experience that countries are bringing, or delegations are bringing to the table on this. So on the damages, the way forward was not to bash heads necessarily, but to agree to have a conversation and see what could happen out of that. And I think that probably helps move the working group forward, but it doesn't necessarily mean that any particular approach to damages that's on the table right now, or even that anything can be done on damages, because this is a complicated topic and we'll have to find a way forward that does not get into the substantive aspects in terms of the actual compensation standard, and are there procedural techniques or procedural provisions and approaches that the working group can consider that can help cordon damages off. And some of that may be better guidance on how to calculate damages. But again, these are topics that still need to be decided. Thank you.
Thanks very much, Karen. I think I'd like to start off our discussion by posing a couple of follow-up questions about some of these individual topics, and then we'll also throw it out to the floor for questions as well, because I think there's a lot to discuss here. I had one question for Margie List on the appellate mechanism. I mean, my understanding is that currently the discussion is sort of separating kind of these function questions from the form questions, right?
Mm-hmm.
We'll think later about what this is, how it's going to operationalize. Let's talk about what it will do.
Mm-hmm.
My question is, does that mean that we've essentially set aside entirely the discussion of whether this will come into existence at all? Is that now just a done deal and that we're going to have something? Or is there still a whether discussion happening at all?
Well, thank you. So first of all, there's no decision taken on if we are going to have an appeal mechanism at all. So that haven't been decided. So it's the same for the multilateral investment court. So, and well, yes, the issue that I address are the issues under discussion. That is pretty much how it will function and what will be the scope. But then, of course, there's the other question on the form, that there have been some discussions on that, but there's no decision either on whether that the best way will be to have a standing appellate body, or if a roster could work for putting in place an appeal mechanism. And of course, there's a huge difference whether we're going to have a standing body, because we will need a secretariat, we will need funding for that, who is going to fund that, it's all money. And then with the roster, even if we could say that perhaps there wouldn't be really, we couldn't achieve that coherence by complete, because there will be different arbitrators or members of the tribunal. Then there's some that argue, and I would say, I mean, there's no position taken here, that a roster could fit more easily to the current system, because it could be administrated by the current institutions such as ICSID or the PCA or others.
Mm-hmm. It does seem like follow the money is always an interesting question, because you know, you can think ideally about how you design an appellate mechanism, or you can think about how am I going to pay for it, and that might lead you in different directions.
Yeah, I think there's a follow-up question.
just to repeat for the benefit of those who aren't in the room, the question was, what's the discussion in terms of the binding nature of the decisions for future cases, as I understand?
I don't recall. I don't know if Karen will recall if there had been a discussion on that. But I would say that part of the advantage of having an appeal review will be that will be as a precedent for other cases. So, but I don't know. Yes.
Yeah, if I can just jump in real quick. There hasn't been a final decision on precedent, but it's an excellent question because it begs a separate question: why have an appellate if it doesn't have precedent? But that said, precedent brings with it some potential risks and downsides. And one of the things that I think the working group has not really grappled with and is sort of trying to, I think, put its head in the sand on are these potential spillover effects. Because you'll have a couple scenarios. One is state A and state B are parties to the appellate body, and they agree that they will abide by an appellate review mechanism's decision. Great if it's consistent with what they agreed, but what if it's not, or what if it's different than what one of them has been saying for a long time? Now, the other thing that we're also very familiar with in the investment context is many treaties now have identical language that they have picked up from other treaties. Now, if you're state C and you're not part of the appellate review body, but your language has been interpreted, what does that say? What does that mean about the interpretation of your treaty? Some reactions have just been, well, just don't join, or figure it out on your own. But it's really not that simple, because an appellate review mechanism will be expected to have some greater authority than, say, another arbitration tribunal or the U.S. Iran Claims Tribunal. And even the ICJ, which by its statute says the decision is only binding on the parties with respect to the particular dispute. So we do have to think about what possible guardrails are out there if we're going to go forward on this. And I think this is one of the issues that could be a sticking point in the discussion as we've gone through. I mean, Margie did a great job of sort of laying out how this will operate, but there is still this larger question of how does it operate in the context of what we have now. Thanks.
Yeah.
If I might add a comment and then a question. The comment is, one of the most common questions from those who are not familiar with arbitration is there appeal? And the answer has always been fairly easy, no, but in some cases there's these other mechanisms. And one of those in ICSID cases is annulment. And you mentioned, Margie, the interplay there. Obviously, there's been increasing annulment attempts in recent years. To what extent do you think dissatisfaction with ICSID annulment is driving the conversation for the appellate mechanism?
Oh, that is the key issue, because actually errors, and I mentioned it, errors in the interpretation, so the lack of coherence, lack of predictability of those decisions are the ones that are actually driving all these discussions. And I think that's why many of the countries that are participating are more open on the idea of having a kind of an appeal mechanism, even if it's not, a whole de novo review, as I said, because that also have implications on the cost and the duration of the proceedings. Yeah.
One question on maybe picking up on the sort of the interplay with ICSID. Karen, you alluded to the fact that, of course, the discussion on the procedural and cross-cutting issues is coming on the heels of ICSID's own reform of its rules. And I noted that what the discussion paper said, it was taking into account the recently amended ICSID rules. What do we see as that interplay going forward? I mean, I think you suggested that maybe some of the issues that were being discussed might move off the table or move into a different space. Are there other ways in which the ICSID rules are coming into play in the discussions?
Margie may have a different view, but I mean, I think it's primarily in the UNCITRAL process, or the UNCITRAL arbitration rules. And the question now is, would it make sense to have treaty provisions that would override or duplicate or what have you, the ICSID rules, or might it be better to have the UNCITRAL rules be on and the same sort of parallel or provide the same types of protections so that you don't have, I don't want to say forum shopping, but I mean, that states are confident that they are seeing the same process in the two major rules that are being that are used in these cases. I mean, I think that's the primary way. There may though also be discussions, there may be some delegations who thought the ICSID rules went too far, some who thought it didn't go far enough. And one question will be, is that a space for treaty language versus the arbitration rules? But we're really still at a fairly preliminary stage on that aspect. So I think it's a watch this space.
And if I may jump in. So, and I know that in the audience, we have Meg Keener and Martina Polsek. So if they want to jump in after me, please. So, no, I agree with you, Karen. So we need to differentiate. And it was raised in the last meeting that there was a risk of using treaty language for those rules that are procedural rules. So it was the part B, because then you will, if you apply it to all, and the idea of the treaty language is to apply it to all treaties as well. So not to your future treaties, but also to the stock of treaties that you have. So, so in that case, there could be a conflict with the new ICSID rules, because you will have, you know, those provisions that may conflict in cases where ICSID will apply. So, and this is a personal opinion, the idea will be with those type of rules to put it in an UNCITRAL rules, like an annex to the UNCITRAL arbitration rules that would apply if an investor choose the UNCITRAL rules for the proceedings. So in that case, they will also be bound by that annex that will apply to ISDS. And then you have all these beautiful rules that we're working on on procedural matters.
So I'm happy to open up the floor to questions if we have any. We have one question in the chat comments asking on the subject of the appellate mechanism, if there's a conflict with the fundamental concept of party autonomy and arbitration, one aspect of which is arbitrator selection.
And
I have a first thought on that, but I bet you do.
And they have her hand raised, but I could address that. So, there have been a lot of discussion on that, but in particular with the multilateral investment court. But because with the multilateral investment court, you have the two tiers, so so then you lose the party autonomy to choose the arbitrators. But usually, what you have in the annulment proceedings, nobody really choose the arbitrators, because in ICSID, so it would be so the center that would appoint it, and then in when you have an UNCITRAL annulment proceedings, then it will be a tribunal of the local courts. So actually, you don't have that right to choose the second tier tribunal. So.
Right, and I should, to be fair to the person who asked the question, they did acknowledge that already exists in the ICSID system to a degree. But my apologies, Jay, because I didn't see your hand raised, and so there are probably a number of these issues that you want to jump in on. You should have just interrupted us. So please don't hesitate to do so.
No, actually, I just wanted to touch upon the last question. It's not only about the selection of the arbitrators or the decision makers that we're facing. We're currently preparing the next papers for the standing mechanism and the appellate mechanism. And one of the issues that we face is actually the jurisdiction of the standing mechanism or the appellate mechanism, especially if it's established as a standing appellate mechanism to hear cases coming from arbitral tribunals. Now, there has to be some sort of a mechanism where the parties need to consent to the appeals mechanism. So this consent to appeal is just one issue. And the idea is that there's, I think, 3 levels of consent. There is the consent to arbitrations in BITs and FTAs, where investors have a claim. So the states have already expressed their consent to these measures. And then when we create a standing mechanism, there has to be a consent by the states to bind themselves to the jurisdictions of the tribunal or the standing mechanisms to hear those cases. And there, I think there has to be some sort of a mechanism to capture the consent of the investors when they come in, if there is an appellate mechanism. So not only about the selection of the arbitrators, but there's a consent issue about how these will be binding on the investors is another issue that we're facing. And this is something that we don't have a real clear solution to at this stage. And that's just one thing. Just going back to the geopolitics, I think as I think Karen or Josh has mentioned, the experience of the member states are different with regard to ISDS. And I think that's kind of the dividing factor rather than developed or developing countries. Now, in the preparation of the advisory center paper, we've been asked to categorize different states depending on developing LDCs. But apart from LDCs, it's quite difficult to see whether the developing countries and the developed countries have different perspectives. I think they have it really depended on case by case. And one of the other aspects is what kind of reform they see as the best solution for the reforms is also behind their engines of what the priority of the reform should be. So I don't think it's the geopolitics, but there's a lot of different interests in the back that is functioning to divide the groups and states into different groups as one of the reform elements, or depending on the different reform elements, I would say.
I would just add on that last note, thanks, Jay. I think that's quite right. And you could think even in terms of, again, Washington, what are the politics of investor-state arbitration in the United States? They're quite interesting and unsettled. I mean, it's a space where in some ways the opposite ends of the political spectrum have both expressed views contrary to investor-state arbitration for different reasons. One side saying it's potentially infringing on sovereignty, and other side saying it's potentially infringing on the ability to regulate environmental and labor issues. So even within a developed country here in the United States, it's not clear how the politics fit on all these issues. And I think, therefore, as Jay said, trying to categorize broadly developing versus developed countries is not that clean of a fit. And probably, as Karen said, the better way to think about it, although it's a bit idiosyncratic, is what is the particular experience of those states in investor-state arbitration? Because it should not be a coincidence that when states have faced very significant claims based on their own governmental measures, they sometimes then have a little bit of a resistance. You can see this with Australia in the Philip Morris case, Vattenfall in Germany, and others. And so it's better to focus individually on those circumstances, and it's hard to make these broad categorizations.
We have some questions here in the room. I'll take the one in the middle.
So as you pointed out, there are this type of advice. So when you discussed that advice, me and the author of the state, has the advisory center been focused at all on that experience? And so will that help one state to or how do they actually think?
That's a great question. So the question, just for those online, is how will the advisory center be cost effective by enabling these potential teams of representation for developing states? And probably the best way to think about the answer is to think about the alternative. So if a developing country faces a significant investor-state arbitration claim, what are the options right now? Right now, the options are try to put together the right team of government lawyers to defend the country and or retain outside counsel. And although in some cases the rates are not the same as they would be in other circumstances, that can be expensive. And so in a way, the alternative is the advisory center might be able to provide a more cost-effective, it wouldn't necessarily think about it as pro bono, but almost like a public defender type role in representing states in a more cost-effective way. Now, it's going to be complicated because where does the financing for that center and the employees there come from? Part of the idea is that it comes from the members who join the center paying a fee. So there would need to be some calibration of how that funding is going to work. But I do think the premise is it's cheaper than the alternative is the idea right now.
If I could just jump in too, I mean, the question that you ask is really kind of at the heart of some of the discussions on the advisory center, because there is a sense that on the one hand, there is probably a high demand for legal representation, but that is the most resource intensive and therefore probably the least likely to provide the broadest type of assistance. So a couple things are being considered in the context of the other services that the advisory center would provide would be capacity building. Now, people tend to think, oh, there's lots of capacity building. UNCTAD does this, ICSID does this, but there are other types of capacity building that might be maybe more carefully harnessed in an advisory center. And one of them is to sort of replicate a forum where states could come, it would be state-led, state-driven, state participants. And, you know, as we were alluding to, there are some states who have quite a bit of experience with ISDS, and it's the gamut, you know, from the US and Canada to Panama. I mean, Margie is more of an expert on it than I am, certainly at this stage. You know, that can share their experiences on the types of nuts and bolts things that go to what Josh was mentioning. How do you set up a team? How do you manage outside counsel? How do you, you know, sort of work on these types of things that when a state is first faced with the case can be quite daunting, but might be very efficiently, information might be efficiently relayed to the state in this type of context. So there's trying to think outside the box a little bit in terms of how we might approach this.
And one other comment on that is that developing countries that have recent experience defending against investor-state arbitration are already doing this to good effect. They're looking for outside counsel to help them build their own capacity so that they are better equipped to defend themselves in future cases, which is certainly a prudent and a good approach. And this is meant to complement that. And the one final piece, which I think is an easy thing that the advisory center would do for all countries, is a center for information sharing and best practices. And I think that certainly is going to enable synergies and make these defenses more cost effective.
I think Jose Antonio had a question.
Yes, on the advisory center, perhaps Margie and Karen could further comment how much of the discussion is being centered on the knowledge that has been gained already by state representatives. And I say this because one of the things that I find in our practice is that it is very private counsel driven, and in the advisory center discussions, although I have not been there during this UNCITRAL discussions, I was there before. Many years when the discussions were not in UNCITRAL Group 3. One of the elements that I find of great importance is the experience of states and how much input our states representatives and those that have managed disputes, even being counsel to disputes, will be able to input into the center. So that's question number one. Two, is there any sense, and I say this knowing that it might be a difficult question, or in this context, is there any sense of whether there's greater support for the appellate mechanism than for the standing court, or the other way around? Yeah, and the last one is, do you have are there any questions as to the legitimacy of creating either, especially a standing court? Are there any legitimacy issues considering the fact that there are currently various investor-state arbitration awards that European states are refusing to enforce and that are now part of international law? I mean, are there any questions in terms of, well, you're proposing a standing court and yet you're not abiding with the rule of law or the international rule of law? And feel free not to answer the last two questions. I know that they're not that easy.
Yes, the third one, I don't think I will be able to respond.
I see everybody backing away from the microphone.
But so on the advisory center, so we have to understand that it is built on two pillars. So one pillar is the capacity building, the training, the forum that Karen was referring to. So the whole idea of that exchange of experience, and I think that is what you're referring. So those states that have more experience in ISDS cases, so could exchange with others that are still, starting with their first cases and are not that experienced in the process. So, and then the second pillar is the legal representation. And there's have been a lot of discussion on what members have the right to what. So, because there will be different kind of levels of members, and it haven't been mentioned here, but also there have been discussions on whether SMEs could get into at least the first pillar, which is the capacity building and the exchange, and that is have not been defined. And actually, it had been really how do you categorize that discussion? It was very
lively.
lively. I like that word. Yes, I like that word. So, but yes, that will be on the two pillars. So for the appellate versus multilateral investment court, of course, we cannot, countries have not decided yet on any of those, but you can tell that at least what, and this is also my personal opinion, that there's more openness for the appellate mechanism, than having a whole multilateral investment court that would change everything, because then that we will definitely will have a different system. So
yeah, thanks for the question. I don't have anything to add on the advisory center. I think I agree with what Margie said. And again, I think the forum and other types of capacity building, and also ensuring that when we're talking about legal representation, that it's very clear that the state should be driving the case and not having the advisory center telling the state what to do or sort of stepping into those shoes, because of course, ultimately it's the state that is in charge of the interpretation of its agreements and in charge of its defense. And so the part of it is building that capacity to be able to execute that, regardless of whether it's a private law firm that you're supervising or the advisory center. On the two questions that you asked, I'm going to use them to pivot to a different point, which I think they're useful to highlight. And that's that, the working group was successful in bringing the codes of conduct to conclusion, but the issues that face it will raise some of the types of questions that have been asked, about legitimacy and what have you. And we're going to start to see, I think, it may be harder for delegations to agree. And the question then going forward will be, how willing are delegations going to be flexible to find new solutions or think about these problems in a different way, in terms of, the issues that motivate the EU on the court? Are they flexible on achieving those objectives in a different way, or is it the court and that's it? Because the flexibility will probably determine ultimate success. UNCITRAL is usually successful when it focuses on the solving problems through the objectives and not so much on trying to adopt a particular approach. And whether this project going forward can follow on that is going to be an open question. I think the types of questions that you're flagging there are ones that are going to be tricky ones for the delegations to address.
One other thought on that is that, in a way, regardless, or if it doesn't succeed in the working group, there is still the EU in recent investment treaties having investment courts, and it's going to be interesting to see that experience. And I think it'll be an interesting day when an investor state arbitration tribunal cites to a decision of an EU investment court. And, it's not going to be binding precedent, but there will be an analogous case. And so I think in some ways we're seeing this fragmentation, and it's not necessarily something to be concerned about. It's an experiment to see what is the most appropriate way to resolve these disputes. And it's going to be hard to find agreement on one whole cloth solution, and we might have to live in this era of fragmentation to see which one prevails.
Well, maybe I'll take the prerogative to sort of bounce off of that and pose a final question, which is, given the point that you make, Karen, that some of the issues to come are going to be harder to agree on than the issues that have already been tackled, which is a standard approach to these kinds of things. Somebody yesterday, I think it was Jeffrey Commission yesterday at one of the panels, described the working group 3 process as, 5 years and no end in sight. When will we know when this is done? And how far away is that?
2026. No, I didn't mean to jump in on your question, but I think the working group now has a plan that shows that we has additional resources that address this to 2026. I think after that, it's hard to say, will it be success or failure? On the one hand, those who are familiar with negotiations know that you need a deadline to move forward, and then the deadline passes and you keep going. Whether or not, though, UNCITRAL, the commission would decide to do that, I think we'll really have to see. I think that is an entirely open question. And to quote one of my former colleagues, anyone who tells you they know the answer doesn't know what they're talking about. So.
Anyone else want to offer any predictions?
No, well, just on your question, that thing is that there's different type of solutions. So the code of conduct was mentioned. It was finished and it could be implemented, because it could be implemented through new treaties, even if we don't end with the multilateral instrument adopting the code. The code live for itself. So, and there's other solutions that are going to, well, that's the whole idea, to also have it through all these periods, from now to 2026. So we will see. But at least I think there will be some products that we could say, at least we have that, if we don't end, with a whole multilateral instrument.
Mm-hmm. I see that Jay wanted to chime in on this.
So just on the products to come to you, to the working group, I think the only thing that's kind of remaining is the multilateral instrument. And then that kind of fits the picture. And then, of course, 2026 is an ideal goal. But of course, we have a little bit of time to implement that further. I think one of the other questions is whether UNCITRAL is the right forum for discussing all of the implementation issues. Of course, if there are some reform elements that's been discussed by the working group, presented to the commission, and it might be that some of the member states might be wishing to pull that further, if among those member states that wish to actually pull those reforms further. So I think that's what Josh was kind of hinting at, in the sense that it doesn't have to be UNCITRAL that implements all of the reforms. Now, I just wanted to go back to one of the issues that Karen raised. I think the procedural elements of the procedural rules is something that the working group is able to agree on. Now, it's probably likely that the governments would be able to agree on some of the solutions there. Now, putting that into the UNCITRAL arbitration rules, we love the UNCITRAL arbitration rules, but the problem there is then this agreement by the working group, the governments that are actually negotiated in these reforms, is enacted into the rules, which is then up to the choice of the investors. So it kind of loses the effect that the reforms that the working group has kind of put together by putting it into the rules. And I think that's why one of the proposals from the Secretariat is that it may be better placed in a treaty language rather than in the UNCITRAL arbitration rules, which is an optional that, and of course, exit rules is 80%, about UNCITRAL rules is about 20%. So the applicability of those procedural reforms might not have the impact that we wish or the working group wishes to have. So that's my last comment on that.
Thank you, Jay, and thank you to our panel. I promised to give the floor back to Jose Antonio for an announcement before we wrap up. But even before he makes his announcement, I just want to say thank you very much to all 4 of our panelists for a really fascinating discussion. So.
Thank you, Maureen, and thank you for indulging me, and also indulging the Washington Arbitration Week. I just as a concluding statement, I think that UNCITRAL Group 3 has done an incredible job in terms of negotiations. It is so complex to have so many delegations in the room, and as many of you were saying, there are already products in terms of the code of conduct and so on and so forth. Of course, there's so many issues and many of them challenging. In any event, the announcement that we would like to make today, given that we're being seen here and online, is that the World Arbitration Update, which is the sister event of Washington Arbitration Week, is launching its dates for 2024. And for those of you that might not know what it is, the World Arbitration Update is a similar forum to the Washington Arbitration Week, but that happens every year in May. And it's similar to this one in the sense that it's a 7 to 5 day event full of arbitration panels, international commercial arbitration, investor state arbitration, and public international law panels with two missions. One is to update the international community with on topics of investment arbitration, international commercial arbitration, and public international law. Update, why? Because in today's world, it is impossible to read 100 ICSID decisions in 1 year or more. And similar ICC and UNCITRAL, etc. So we try to do a little bit of a format that would allow people to update themselves. And the other mission is to decentralize international arbitration, because there are many sites and places where international arbitration is happening in Latin America, in Africa, in the US, that might not be the Washington or the New York or the Paris or the London. So that's another mission that we have. And this year, we're going to start on May 15th through 24, and we're going to start in China. We know that there's a delegation and many people from many countries coming to Washington Arbitration Week, including China. So we're really elated by the fact that Washington Arbitration Week is, yes, for the international community of Washington, but also for the whole world. With that, thank you. And we hope that you can join us also in the World Arbitration Update. Thank you. Wow, too. Thanks.